Good afternoon, everybody. Wanted to welcome you back after a wonderful lunch and invite you to our session 2. It's regarding whistleblowers and effective whistleblower systems. I think one of the things we want to talk about today and the lessons learned from this morning when we had DOJ speakers is that, as they were saying, the risk of detection by the government is one of the most important factors for a company in determining whether to self-disclose to the authorities. So I think what we want to talk today from a couple of different perspectives is what is a whistleblower? Really, what are the different ways that they can bring information to the company, to the press, to the government, and what are the lessons that we can learn. So my name is Nathaniel Edmonds. I'm a partner at Paul Hastings here in Washington, D.C. I spent about 10 years at the U.S. Department of Justice in the fraud section, where Lorinda is now. And then I've been with Paul Hastings for about 10 years. During my practice focuses on international investigations and compliance. I do a lot of work in Asia, and I've actually lived both in Japan and in China. So I think that what we want to do today, and we have each of the panelists introduce themselves, and we want to have a good discussion among the panelists, but we also welcome questions from the audience, because I think this is one where we all have slightly different our work with these in research. I'll start with Mark.
Thanks, Mark Schneider. I'm a partner at Kirkland & Ellis, based in Chicago. I too spent about department, mostly in the U.S. Attorney's Office in Chicago, but also doing some national security related work in D.C. I spent a year in Baghdad during the war doing law related work there. My practice at Kirkland is white collar, investigations and defense, including and elsewhere.
I'm Eugene Soltis. I'm a professor. My work focuses on data to understand organizational compliance and culture. I'm lab outside of applies some of this data knowledge to assist firms in their organizational culture and also running their firm hotline systems.
Hi, I'm Alan Milford. I'm a partner in King's law firm. Part of my career has been spent working as a prosecution service, where I ended up doing all sorts of organized crime cases, and then as general counsel of the Serious Fraud Office, where I worked from 2012 to 2018. I've been with Kingsley Natalie then for the last 4 years, and my work involves white collar crime, corporate investigations, and some process of crime as well.
Hi everyone, I'm Lauren Casada. I'm a partner at Kirkland & Ellis in our New York office, and I have never worked for the government. I guess I do clerk for a federal judge, but other than that, I am a civil litigator, but I also do a lot of government-facing internal investigations related to what we call workplace compliance or Me Too issues. And I also established our crisis response practice, really sort of runs the gamut of all different types of legal crises, but in communications advice. So how our clients are communicating to investors, to clients, to media about the crisis.
Great, and I think what we tried to do with this panel and Daisuke in identifying, everyone has slightly different background, everyone has slightly different experiences, even within the government and the advice that we provide now. And what we kind of want to walk through now is what does this mean to be a whistleblower? Right, a whistleblower, I think the standard understanding is someone who has information and tells someone else about the potential misconduct. But there are lots of different motivations for that. There are lots of different methods of communicating that, anonymously, by name, with documents, without documents. And then ultimately, Who are they giving that information to? Are they reporting it internally within a company to their manager through a more formal speak up or whistleblowing hotline system? Are they reporting it to the press, either through lawyers or anonymously? Or are they providing it to law enforcement? Or even at times, are they going to the government to get a bounty? So one of the unique aspects of the US government is that there is a bounty system where you can get a reward by providing information in certain circumstances. So all of those are different ways that we think about what and how that whistleblower acts, why they are acting, can have different reactions from the company and from the government. But let me first start with generally how the process works. What happens when there's a whistleblower, and when someone calls in with a question, what's that for? And let's start with Eugene, since you both have an academic perspective and a business perspective, in that your company sometimes manages these topics.
So when you think of someone has something that they're concerned about, and it's not necessarily a violation of law, but it's actually something they're uncomfortable with. There might be a similar process violation or an alleged process violation. We would hope that before it gets to what we call formalized process whistleblowing, they're going to raise that to maybe a colleague or their manager. Some instances that can't be remediated or unsatisfactory feedback, and so this is where those centralized like whistleblower come into play. And this is when then the reporter will actually speak up. So generally, they're calling a number or going to the website and providing that information, which then becomes formally investigated. I know some of the pieces associated with that. But once it becomes formally investigated, it generally goes to the compliance office or legal office from the company. Depending on how that company is structured, that might be within legal, most commonly, but it could also be in HR or some broader function, depending on the size and scale of the company. And then it's the company's responsibility to figure out how that should actually be addressed. And that's where either effective work can be done to actually try to appropriately address that, or we also see that's where mistakes, probably can also occur. And it's not effectively either investigated or remediated. And that's actually the critical point once it's centralized when people here become involved is their outside counsel will help support the additional investigative work that's being ultimately either substantiate that or take additional action or describe that as that not something that needs to be further investigated unsubstantiated, so no additional action would be taken. So that's when it's within the company.
But many times it doesn't go within the company, or as we may talk about later, it is raised to the company, but it is not effectively dealt with, at least according to the reporter of that information. When that person becomes frustrated, where else can they go? Well,
and in that situation, usually the company has a little bit of an advance notice or heads up that's unlikely. Now, if it's in a scenario where someone's disgruntled and has not felt heard, has raised the complaint internally, or gone to the government and that investigation isn't proceeding case, and we've seen this in recent headlines, people are motivated to get the story out there. They're angry, they're upset, and they're actually more driven, less by their own financial interests, they're more driven by, their passionate feeling that something has to change about the policy. And so, in that scenario, the press in the United States has no obligation to share sources unless they're forced by a court of law. The person talking to the press and sharing information with the press is taking on risk because now they're out there as the complainer. They may be inclined to share confidential company documents with the press. The press needs to verify certain facts. Press, usually good journalists, will not take just one source and write a story about it. And so that person is taking on risk by sharing confidential documents that maybe, and we can talk about this later, if we'll be chicken with the company, maybe the company would then sue that employee for sharing, for violating NDA confidentiality agreements with the company. And so they're taking on a lot of risks by doing that. But certainly, if the whistleblower is able to verify it with documents or with other confidential sources, then it's out there and the press is going to start investigating. And it will put a lot of pressure on the company and a lot of pressure on the government, and the government's also investigating to get moving and to provide some answers.
So let's now turn to what happens if there is reporting to the government. We're going to set aside for a moment the question of a bounty system, but many times there are going to be individuals who are reporting information, they're not feeling heard, and they go to law enforcement, they go to the government in one way, whether it is the local police, whether it's the FBI tip line, whether it is a prosecutor, or a cocktail party, or through a formal complaint. Alan, maybe you can give us your general understanding. And obviously, I think one of the important factors is we're not just talking about a US system. This is a global piece that many of our clients are multinational companies. We need to think about multiple governments that may hear them.
Thanks. The mechanics are going to depend on the individual law enforcement organisation as much in England and Wales, my jurisdiction, as in the United States. Just a quick point about motive, because Lauren touched on that at the beginning of her comments. Sometimes the motives are different to the people who go to the press. It's not a question sometimes of not feeling they weren't heard within the company. It's not trusting the company to hear them in the first place may be the reason why they've gone. So they may be coming to it from a different kind of place. Certainly in the organisation in which I worked last, the SFO, we operate an online portal trying to make it as easy as possible. You go onto the SFO website, you can see lots of warm words about confidentiality and how we're going to protect you, and then you read it a second time and you think maybe not quite firm guarantees here. And that's because they can't give firm guarantees. Because if ultimately the information is useful and if ultimately there is prosecution, there's a very high chance that there's going to be disclosure of some kind. There are also nice warm words on the website about the extent to which your employment rights be protected in England and Wales. And we have a piece of legislation, Public Interest Disclosure Act 1996, which is intended to protect employees of people who have an employment relationship with the company from dismissal or discrimination or victimization within the company. In principle, it's a very sensible and good piece of legislation, but we might sort of get to this over the course of the afternoon. Necessarily work as the human beings concerned would want them to, because really they tend to just want their life back. And what a piece of legislation like the Public Interest Disclosure Act does is not quite give you your life back. It tries to make it harder for the companies.
Absolutely.
What we are seeing is what Lorinda and Lisa, I think what we're suggesting is that they are getting information in from whistleblowers that are starting these investigations. I think the question is how much and how credible it is, but one of the sources which has been discussed as a reason for an increase in reporting of information to the U.S. government are the bounty systems. And Mark, maybe you can explain what that is and how that process works in general in terms of documents and credibility of those types of witnesses.
Yeah, so the US government has very strong incentives to encourage whistleblowers or others with information to share that with the government, and it does so principally by providing financial benefits to do so. The ways in which that can happen, various agencies have various programs, but there are programs with the SEC to report, financial accounting related issues, including issues related to the FCPA. There's a program within tax to report pedophile tax evaders. And one of the largest historically, just from a financial recovery standpoint, is the Federal False Claims Act, which allows individuals to file under seal an allegation of false claims submitted to the government. The government then has a duty to investigate that, and the government can then either intervene and take over that lawsuit, prosecute it against the company, or if it declines to do so, the relator or the person who's the whistleblower can prosecute that themselves, and they receive a large share of the financial recovery for doing so. And when those allegations are, conveyed to the government, whether it's the Justice Department, the Keytown, or the SEC, or the tax division, or a lot of states have similar kind of whistleblower bounty related provisions. Initially, the company, may not know about it. And often the kind of first notice they'll get is sort of a subpoena of some sort that kind of signals that the government's doing an investigation, and that may very well be what's behind it. And when you get one of those, obviously the question is, how did the government kind of learn of this, and who the relator might be? And in some cases you might learn about it because the person who sends a letter to the SEC simultaneously sends it to the company and says, we're reporting this to the SEC and the Justice Department, and here's a copy of the letter for your audit committee, in which case your disclosure decision's kind of already made for you, and you're kind of off to the races. But in a lot of cases you don't know that, or you're investigating an allegation with kind of the knowledge that might be kind of what's lurking in the background.
I think one of the things that we struggle with as advisors to companies is how to respond to whistleblowers. But I think part of what we want to do with this is also think about it from an academic perspective. It's what are the reasons for it? What are the public policy reasons to encourage whistleblowing either within a company or to the government? What are the benefits and disadvantages? And Eugene, maybe you can talk about from your perspective, what are some public policy reasons to encourage more reporting within a company? Why should it be addressed there rather than going to the government?
So I like how you phrase the question, because it's public policy. I'll say I'm going to put on my business school. Within it, I would think that most leaders of the company would prefer in seeking to have a more effective culture in which people are able to work productively, innovate, work on strategy, do all the things that people want to do when they join the company, rather than deal with all of the unpleasant parts. Some of those are the areas, people are feeling pressured, like the bribes, the fraud, things that make people deeply uncomfortable and divert people from effective work. If we start talking about other areas like the HR areas, other areas that no one's working in, I'll say when it comes to discrimination, harassment, other areas. If you actually look at some of the underlying data, when those allegations go unresolved in companies, and when we actually can see unsubstantiated allegations, substantiated allegations, you actually start to see those parts of the organization, literally at the line level, becoming less productive. So I think there's actually there at least is existentially a lot of incentives for companies to try to have people speak up earlier and more frequently, because you can address it before you have to hire counsel. Obviously, it's faster, easier, marginally probably less expensive. But unfortunately, I think a lot of times there are also a lot of, I don't want to think disincentives, but also a lot of cultural reasons why that isn't always at the top of people's minds. I actually think it's very refreshing to be here today discuss this topic because, the prior part of this week, I was teaching the exec ed program, which is basically EVPs, SVPs, very large companies. And when we're talking about what we're doing today, with most of them, this is a very kind of exotic topic that I think many of them don't see as relevant, even though maybe ironically several of their companies are actually currently under EPAs, NDAs, monitorships, but they're able to distance themselves from those people's actions in the company. And so I think that's part of the both opportunity and challenge is creating relevance for within companies that these are things that do happen and happen with, I think, increasing regularity across companies globally.
And I think going from the theory, Mark, you represent companies who have whistleblowers. What are some of the reasons that they would say there should be more reporting within the company rather than going to the government?
So, I mean, I would agree with what Eugene said, and that it's often less costly. I think a company also has, just from a policy perspective, kind of informational advantages in doing an investigation, and that they kind of know who the players are and where information is, and it's just more efficient for the company often operating in good faith to do this rather than having somebody who doesn't know the industry as a prosecutor in Washington, trying to kind of pull this, out of you. And I would also just say more generally that, if you think about why people choose to do, the right thing or the wrong thing, as a child, it kind of begins with the fear of punishment, then it kind of matures to sort of seeking some benefit for doing so, the carrot that we've spoken about. But what you want to have is sort of people, develop virtue, which is like a habituation to the good, which kind of touches kind of the culture, I think, that Eugene spoke of. So you want kind of a culture where instinctually you kind of try to do the right thing. And I think for those, again, like on an individual level, if you take kind of the moral life seriously, part of that is an examination of conscience and understanding kind of who you are and what you're doing and where there are opportunities for improvement. And I think that's sort of what a company culture, different way needs to try to focus on.
But we are talking about the white collar criminal world, so we don't always have virtue in each of the people that we deal with on a regular basis. So what are the public policy reasons potentially to have it go to the government or to the press? Alan, what are some of your thoughts? You were in a very senior position of a very important enforcement agency in the UK. What are some of the policy reasons that it should go to the government rather than in
I suppose at its heart, the criminal law, which the Serious Fraud Office enforced, marks the conduct or prosecution marks the conduct which impacts on society as a whole, not for individuals, not a question of damages for one or two people, but in society as a whole, which is impacted by crime. If someone is aware of criminality, then it is, we would say, or certainly would have said, a matter of wider societal good, that this is reported so that the law enforcement authorities can operate to protect society as a whole. The bounty system, which Mark touched on or just spoke about, is quite problematic in our jurisdiction. Key Town is seen as it's unenforceable. It is unenforceable as a contract, contrary to public policy. And if you look at the old judgments about it, it's really vague about what the moral objection is. It's just, and I paraphrase, not cricket. And that's a bad thing. I remember shortly after joining the Serious Fraud Office, having a conversation with David Green about who's then the director, about what was going on in the United States, and this thing called the Dodd-Frank Act, and thinking, this looks good. I mean, imagine how helpful that could be. And had a quiet word with policy-making departments to say, is there any kind of appetite for giving us something broadly equivalent? And the answer came back pretty quickly. But their firmly was not held with freeze over, basically. It was the sort of messaging we had. So you know, whatever the policy framework is, where UK authorities are concerned, then I think bounty systems are certainly no appetite for that.
And Eugene, from your perspective, what are your thoughts in terms of policy reasons for disclosures to the government or in the bounty system?
There is, I'll say, frustration, that can arise internally. I mean, I like how Mark phrased it with virtue. In one hand, speaking up is considered, I think we all like the right thing to do, especially if there's wrongdoing. I think that's also counter within a company. If you speak up, you're also like the rat. There's strong internal, I think psychological pressure to not do that. I'll say in many companies, you actually look at people think that the people that are on their team, maybe if you're in a manufacturing company that you've been working with them for 10 years, those are the people who you see as your friends. On the weekends, they're going to barbecue, you go to their kids' weddings. That's who you see as your unit. It's not the company. And so I think sometimes one of the reasons why you end up hopping over the company is those are your immediate people that you're seeking to protect. And so we need actually much stronger incentives to actually override, in some sense, those instincts to not be the rat and not to harm the people around us. And huge financial rewards sometimes can, I think, overcome some of those inhibitions that we might have about getting a friend basically fired or worse, cynically. But I think we were all motivated by these complex competing incentives.
And I think what DOJ would say if they were here is that they want to encourage as much information flow to the government as possible. And the bounty system is a very effective way to encourage that and get documentation regarding this, right? So there's a whole now cottage industry, just as with the False Claims Act, right? But the bounty system for the SEC of lawyers who are designed to understand what is necessary in order to enforce the law. And the basic breakdown is that there is not enough detection by the government of the fraud and criminal misconduct that's out there. And so the way to do that and expand the resources of the Department of Justice is to encourage these private actors, these private attorney general, however you would describe it, right? To essentially police when companies themselves are not doing the police. And that's the policy reason behind it. I'm not sure that it works as well in practice all the time. I think that there are breaks and advantages of it, but we work with companies all the time. Lauren, you deal with a lot of crises. What do companies prefer? How would they like it? And what steps do they take to try to encourage their preferred course of action?
Well, this is a no-brainer. Companies prefer that they hear about it, or the government hears about it. There's no question about that. But I think, you know, when the system is working well and the whistleblowing complaint hotline code of conduct is working well, it's, you know, and I usually have to flag this for clients. They get an internal complaint, they're not happy about it, it's setting, and they're investigating. I have to sort of pause and say, well, let's look on the bright side. Your systems worked. It got elevated to the right people. We can investigate it, and then we immediately, you know, move to the investigation phase. And so, but you know, for all the reasons we were talking about in the first panel, I mean, companies want to understand and get their hands around what is this issue. Is it substantiated, unsubstantiated? Is it actually what we think it is in this hotline complaint? Who else is involved? You know, can we, before we, and if this is something we need to disclose to the government, let's make sure we understand all the, you know, different tentacles of it, right? And so certainly I think companies would prefer to know about it in terms of mitigating, rectifying the issue, understanding, taking sort of a pulse on their speak up culture. So absolutely they would prefer to hear about it first. And the challenge all the companies we work with faces, how do we set up the right system? How do we set up the right culture where people are incentivized to do that? Not for financial incentive, just because we, the company, are saying we want to know what's happening and we want to know if bad things happen. So, you know, I think absolutely they want to hear about it first.
I think that the key there is they want to hear about it first. They want to hear about it before the government does. But I think there are times, and I think you kind of referenced this, where the company sometimes doesn't want to hear about it at all. Right. So part of the challenges that I think many council struggle with and internal HR systems and a variety of other things is why look there? Why look under that rock? We don't know what we're going to find, and it may be something bad. If the government is never going to talk out about it, why should we be the ones to go in there? There's no legal obligation to. We don't want to know where these bodies are buried. What are the risks of that? What is the impact of such a position? Mark?
Yeah, I mean, it's a very, I think, just human phenomena of not wanting to kind of deal with hard issues, and particularly those that kind of cast you or your organization kind of in an unflattering light. I think from a legal perspective, I mean, kind of boards of companies have, legal duties under Caremark, and there have been a number of recent cases going, that kind of strengthen that principle to actively kind of oversee the compliance program and to do so in a authentic way. Secondly, as we learned about this morning, in the event that what happens is discovered by the Justice Department, you have at least two problems. One is the department will look at kind of the effectiveness of the compliance program and evaluating what kind of resolution may be appropriate. And secondly, if you don't discover it first, you lose the optionality to make that voluntary disclosure to the Justice Department. So you can always kind of investigate, find out what's going on, and make a kind of rational, informed decision about whether you want to voluntarily self-disclose. But if you don't have the information, you can't obviously do that. And then, third, I would just say that, just from the standpoint of psychology and how kind of norms within organizations grow, if you don't kind of nip things in the bud quickly, they will metastasize and kind of get worse. And there's a lot of evidence about how, newcomers to organization, very kind of subtle social cues about what's acceptable or not, informs kind of people's understanding of what is kind of right and wrong and how we kind of operate within this company. So if there's something kind of growing under a rock, it'll probably, escape kind of that rock and become kind of larger and more risky and more dangerous, over time if it's not addressed appropriately.
Alan, you had some additional thoughts in terms of that?
Yeah, I mean, from a UK perspective, I absolutely agree with everything that Mark said. The culture point, I mean, that's the sign of a pretty unhealthy organisation. That's the attitude of the senior executives. But yes, our direct duty to essentially sort of get you to the safe place about what lawfully directors should be doing to understand what's going on in their organisation, and of course got the information in front of you so that you can make an informed decision about whether or not to support and thereby act in the company's best interest. Famously, under our Bribery Act, there is a defence of adequate procedures. And again, if you aren't looking for information, then you're going to have a really tough time getting yourself any kind of legal defence and the company any kind of legal defence. Less famously, perhaps, under Section 14 of the Bribery Act, there is personal liability, personal criminal liability for directors who consent or deny in the failure to prevent the effect, the corporate effects of failure to prevent bribery. So, whilst the government, we don't need to show if you're prosecuting whose fault it is that the company didn't prevent bribery, if you're able to show connivance by directors, and you can fix them with personal criminal liability, that's a really, really good reason for them to go look at crimes.
And I think in the US, we famously do not have the adequate procedures defense, although there are different people who put that forward. But I think what we do have is the general legal concept of willful blindness, right, or deliberate ignorance, where the idea is that if you choose to look away, you are putting your head in the sand, then you are liable and you are considered to have that intent, to have that act or that occurrence happen. All right, so those are some of the policy reasons, some of the big issues behind it. Let's talk through the actual way it works. Lauren, maybe we start with you in terms of you deal with the crisis side when something comes in, it hits the press, but it also sometimes happens internally. Maybe you can walk us through how, again, no name clients, but like, how did something actually work when someone raises a complaint internally within the company?
Yeah, so we'll presume for purposes of this answer that it's a well-functioning compliance system, which is not always the case. So it depends, the complaints we said could come from various avenues, right? There should be in any code of conduct, various channels to report. So employees should be heard, they can report to their manager, they can report through a hotline, they can report up to senior managers. And so, when that report is received, it should be, the managers should be trained that they are supposed to elevate that up to either the compliance department, the legal department, the HR department. And all of those compliance departments, legal departments, HR departments should be working together so that if the HR department sees a complaint come in from a hotline that really should be over in the legal department because of fraud concern, they should be communicating and coordinating. That is a problem that we see a lot. And then that will trigger an investigation. And so every company has a different sort of procedures for this. But the person who's making the decisions, let's say the general counsel of the company, has to decide, is this something we can investigate internally? Is this something, given the nature of the allegations, they relate to senior executives or board members, where we ought to have outside counsel engaged to do this investigation? So some of those strategy decisions need to be made very quickly and early. And then the very first step typically is reaching out to the complainant to promptly to make sure that they understand that has been received. The company takes it very seriously. We appreciate them coming forward, and we're going to investigate and keep it confidential and keep their identity as confidential as possible. And then the investigation ensues. And there are definitely pitfalls when you can't verify certain things. Some people won't cooperate and talk to you, and so there's all sorts of issues that can come up in an investigation. But ultimately, the company has to look at the information gathered, decide if there are criminal implications, if there are various disclosure implications, if there are policies and procedures at the company that require the management team to report that up to the board and the audit committee of the board. And so we really, all this to say, there really needs to be a robust structure in place with human beings who are making judgment calls when they get these complaints, who are well trained and understand all the legal implications. But that's typically how it works when the complaint comes in.
I think, Lauren, you described the good scenario, the ideal scenario on some of this. Eugene, you have looked at this from an academic perspective. You also help a number of companies improve their systems. What actually happens when a complaint?
So a complaint, I'll give maybe not the disastrous, we'll give the more complex version. So a complaint comes in and it's going to be investigated. I think we get to this nice binary outcome, it's substantiated or unsubstantiated. But in reality, that itself is very complicated because this isn't a court, this isn't like the FBI sending a national security issue. Corporations have limited resources. There's also a genuine concern that there's a lot of externalities associated with investigating issues, particularly if someone's reputation can be on the line. So you're trying to do that efficiently and quietly, which compromises the ability to really only sometimes do a full investigation. In a lot of instances, what you see is, so we've substantiated. What substantiated means, it's not in most companies, this is not beyond reasonable doubt. This isn't even preponderance of evidence. I think most companies have a much squishier standard of the thing. So reasonable evidence of is kind of the standard, even though that's never even sort of laid out. Now, what's really important there is that means unsubstantiated does not mean it's not substantiated. In fact, there's a lot of instances, particularly if we start talking about the HR, like I'll say, harassment space. You can do some really incredibly awful things and have it be unsubstantiated. because it's simply hard to actually pick up that information. I think one of the, interesting challenges that, companies are now facing where data starts coming into play, but it creates different challenges depending on which jurisdiction, is when you start seeing people that have records of many unsubstantiated allegations. What can you infer or do with this? Because I will say, in many instances, since compliance in investigations is run by legal, there's a very what I call legalistic view of the world, where if it's unsubstantiated, you don't take subsequent action. But I think there's a lot of instances in which the behavior is not consistent with what the company would want to create maximum productivity and is in line with the culture, but it's not a violation of the legal rule. And so you will oftentimes see nothing happen. Now, the challenge is employees actually see that, and oftentimes reporters see that, and they see nothing happen. And so what do they see? They say, well, the company clearly doesn't follow up on what I say. They don't respect what I say. And then what you see is that can actually manifest into actually other compliance violations, because people say nothing happens. I don't respect the company now either. And then that can manifest another awful consequences for the company and the employee. Where this becomes, I think, especially challenging now, we see, for example, in Europe, where many, I would say, an increasing number of large companies starting to purge historical records. For example, it's unsubstantiated, you can't find evidence. After 90 days, you're purging that because of concerns around privacy. So, in some sense, there's kind of this perverse world that you can actually do pretty awful things, and every 90 days you get kind of like a clean record with a chance to do over, even though you're actually creating a lot of harm to both people, the company's culture, and the company itself, but it's always just a little bit below the threshold. And so I think when we start talking about what happens, it's messy, it's complicated. And I think that's also inevitable because you're resource constrained and you're trying to do things actually to not also adversely harm people's reputation in the process of actually trying to figure out what's going on.
So we've talked a little bit about what a company does when it gets the information. Maybe we can also talk about what does the government do when they get a report of information. Alan, I don't know if you want to provide some examples of from your time or an overall perspective on what government does.
So I think an overall perspective might be the way to go. Thing to understand is the government has a huge amount of data in a huge number of different data sets, and one of its macro challenges is to understand what that data is, how it may or may not connect, and how that might help you start putting together a case. And I think sort of touched on this morning, when information comes into the Serious Fraud Office, whether from a confidential reporter, whistleblower, or any other source, it's triaged, and it's triaged really quickly, with the aim of working out whether there's anything that can be done with it. If it's sufficient, if it's too vague, then it's useless. But it may be something that someone else would be interested in. You get it out to them very quickly, so that you try to leave yourself simply with the data that you think you may be able to work with. And then you will start to check it against publicly available sources, against other intelligence databases across government, and I'm pretty certain that's standard across Western democracies, not just the United States, but across Western democracies generally, and goodness knows what goes on in autocratic states. So the idea is that you are able to get as full a picture as quickly as possible, and then what they will do with that better understanding is go back to the person who provided the information to see then whether there is more information they could give, and to see whether they may or may not want to move the relationship to a different kind of relationship when they become an active source, what we call a covert human intelligence source of chits. But I'm sure there's the same, different words for the same concept in the United States.
And Eugene, I know that your company also does some work with the governments in terms of some of the, or at least you've done some analysis on government reporting systems. What is your perspective?
And so, I mean, one of the systems we run, so It's for the General Accountability Office, so hopefully you don't have fraud about the US government, but if you do, that's what something, my organization runs. I mean, where we're spending a lot of time is, I will say, I appreciate that speaking up in the whistleblowing process, it's a legalistic process, and there's a lot of rules and regulations and processes around that. But it's also a very deeply psychological process, and Mark, all the things that you're. And so where we've been spending a lot of time, we've actually seen a lot of variation is that subtle changes in terms of the questions that are asked in the ordering. So, most firms, their whistleblowing system looks like a legal form. And if obviously you're rightfully, hopefully there are not too many people that are enthusiastic to whistleblow, or the rare, but most people are really a little bit anxious during the process. And you enter into legal form. And the first question you actually ask is, do you want to be anonymous? I'm actually surprised more people don't select that box initially. You don't know what you're being asked on the phone, and you don't know what you're going to say to the questions you don't yet know. Most people, or many people, default to being anonymous. That makes it very difficult for companies and governments to actually then subsequently investigate the matter. It's much better if you can, if the person has trust with you, you trust them, that you can now get to the bottom of things both more efficiently and generally more likely than not substantiated if it deserves to be substantiated. So what we've been spending is a lot of time thinking about the subtle ways in which you actually adjust the questions and even the organization of the questions. And I can say, across our systems, one of the first things that we did is change from the first question is, would you like to be anonymous? Hold everything else equal. Let's move that question to the last question in the flow. Holding all else equal, we see anonymity rates across, and this is both government systems and private company systems, fall next 20%. Just in that single change alone. And I don't think most people they actually seem pretty intuitive. If at the end of the stream of questions, you now feel comfortable with what you provided, identify. If you actually then follow up, look at the speed of the investigations and the ability to actually substantiate those, it actually goes up in a statistically significant fashion thereafter, simply because now it's just easier for all parties to be involved. So there's a lot of, I think, small tweaks that we start thinking it not simply as a legalistic process that firms need to check the box and have, or that the government also needs to have because various responsibilities. But we think it's a deeply psychological process that we can tweak things in order to support that person's journey in that speak up environment.
One of the pieces that sometimes happens is when you're gathering that information, people are complaining about, as I think you described before, just something they're uncomfortable with, right? They don't know what the violation is. I think every company and government struggles with how to classify various different complaints. Can you give us some examples in your background of what has happened? Have you tested this in such a way about how companies can classify different types of complaints?
I think this is one of the most challenging areas for a company because compliance is cost center. That's just practically how every single leader thinks of the compliance and function until it becomes so prominent. It's something different that now it's on their focal point. The problem is you oftentimes have people answering their phones that are paid $25 an hour. You're having sometimes HR, and so if you're not at very large companies, generally a lot of times it's HR running the systems that are not going to have just allegations that are on discrimination or harassment, but you have fraud, security violations, bribery, all these other areas. And a lot of times people that are calling to report don't articulate it in the way that an investigator or certainly an attorney would. You call, and what we've actually done testing is, and I'll say one of the testing that we did with the support of a set of companies is, calling and starting out that complaining. And this is the one we did earlier in the summer. I called, I wrote it down verbatim so that we could look at the internal system and see how this is captured. But I called and complained how my manager is accusing me. I missed my son's baseball game. I'm going to miss it again next weekend. And I'm just blabbering on and on. And then at the end, I basically give a very clear allegation that I'm engaging in fraud because, again, that's why I'm missing my son's game, because I have to move these accruals around. It was very clear. And if you actually look at the internal systems and then how it gets processed and then closed out, it always started that complainer is missing his son's baseball game yet again, believes their manager should be fired, and the manager called them and uses lots of colorful language. And it looks like an HR matter. Where like if anyone was looking at anything in this room or anyone in the audit was looking at it, they would be actually quite careful. This was a very clear fraud allegation. I always like to throw a little government in fraud, because now it's like double fraud, that's fraud, now we're actually defrauding the government, false claims, all kinds of fun. But I would say that's the challenge, and I think it's how do firms devote the appropriate resources internally between HR and audit to make sure when actually serious matters come in, they reach the right audience. Sometimes it's maybe internal audience, or the company doesn't have the resources to figure out when those could be appropriately routed to external counsel or other support sources.
I think that misclassification is always the challenge, right? You may have a very good system for responding, but if you are just outside of the scope, right, how do you deal with it? And maybe Lauren, you can respond to what results with this misclassification, right? So if it ends up in the wrong bucket, what's the impact on?
You won't believe this, Eugene, but I have a case of matter right now where almost the same thing happened as your hypothetical of the baseball game, where a hotline email complaint came in, and the person, I'm going to try to, anonymize this, but the person alleged, didn't get along with his boss on the floor of where they make this product. And in the description, used the word fraud, I think, and described in detail something that happened before the government was coming that this person thought was fraud. The general counsel got this complaint, was not alarmed by the word fraud, and sort of had the reaction, people use that word all the time. It's sort of an investigation, and ultimately concluded this was an HR issue. He just had beef with his boss. He was kind of making this stuff up. He threw out the word fraud to scare everybody because that's like a criminal thing. And case closed, not reported up to the board, not reported up as far as we know to the CEO or anyone senior. And what is the effect of that? Well, it came up in a production, related to something else. And the government said, well, what is this? And it's creating a lot of problems that could have been, rectified, mitigated if and this is the challenge, right? If the folks that are receiving these complaints are trained accordingly, or, appropriately, if you have the right procedures in place, like, I don't care what it says, or if you hear that word fraud, it's got to be elevated to this person and that person. So many companies don't have that. You would think they have it, they don't have it, and so things, fall through the cracks, and it really can have, ramifications later. But he's just upset with this person. HR kind of thing, I think, happens a lot, and I think, sometimes that's where hiring external counsel to investigate. Or even just to call external counsel to say, when you think about this, can be helpful, because you kind of have to pull yourself out of the corporate culture and look at it, with fresh eyes. But it is a problem, and I think it's a real challenge for companies, particularly if you have limited resources or it's a challenging time for the company.
Mark, I think one of the things Lauren mentioned was calling outside counsel. I think one of the challenges on these whistleblower internal reporting is when do you call outside counsel, and can this classification end up having things be investigated not under privilege versus underprivileged? Can you just give us your thoughts on the benefits of conducting under privilege, the downsides, and where do you think companies sometimes make that call?
Yeah, and I might just echo what Lauren said. I have two other live cases with very, very similar factual scenarios to what Lauren and Eugene just described. So this is like a very common issue. And I think it's also like a broader issue, I think, just about design and compliance programs to like what the risk the company actually faces is. So like a lot of big international companies have well-developed CPA compliance programs with their huge enforcement actions, but they may not have a program that's designed for like, their dealings with, manufacturing quality, or their interactions with the, EPA emissions related issues, or, lots of other kind of regulatory risks where these things, can come up. So I do a lot of work in like life sciences, pharmaceutical space. In that world, companies have very mature kind of manufacturing quality organizations under the jurisdiction of the FDA. It's kind of to HR lines that, arguably raise a quality related issue that needs to get triaged and sent to the kind of quality investigation kind of work stream. So on the privilege question, I mean, the threshold question, I think, is off. I mean, it's more expensive typically to have a privilege. It's also the case that a lot of companies in regulated spaces have duties to disclose, what they have done kind of automatically. So like in the FDA space, for example, like, you're 99% of kind of quality investigations that device company, pharmaceutical device company is going to do, it has to really be done in a way that the FDA has complete visibility into what's done. It's documented in a way it's going to be inspected during FDA inspections. So for that sort of stuff, it would typically, not be done under privilege. I think when privilege becomes important is when there is, a genuine risk of kind of legal proceedings. And that can be, civil litigation in terms of, there's likely to be an connection with this whistleblower or employment action. And obviously it can be kind of, certainly something that would rise to kind of criminal liability or some other kind of regulatory, civil enforcement action by the government would be kind of triggers to say like, yes, we should bring this kind of like a privilege rather than doing it in a routine kind of way. But compliance is a cost function, and if you're having outside counsel for these investigations, that gets expensive quickly. So a lot of kind of the run-of-the-mill stuff, is appropriately dealt with by most organizations in an unprivileged way. So it's a risk assessment.
Yeah, and that will be critical in terms of how you classify it, right? And if you can classify it correctly, you can identify those that need to be under privilege. And if you don't, then you face those risks. And maybe, Eugene, you can have some thoughts. And I think you started talking about this in terms of how to improve it, right? In terms of changing some of the questions or other order of that. But what have you seen broadly in terms of the best ways for companies to test their programs and enhance them to make sure that they're more effective in the long run, or what are some of the common problems?
One of the broader challenges is what I'll describe as paper versus practice. If you actually look at what's on paper for most organizations, so we go like Fortune 1000 companies, it kind of all looks the same on paper. In fact, even I'll say the code of conduct looks pretty similar, but there's vast variation both across companies, but also even within the company, how those actually processes then manifest. I think the first thing for a company to appreciate with some degree of humility is that there's probably variation about the quality of their speak of environment and culture within the company. So if you imagine, the company is really an amalgamation of hundreds of subcultures, which of those do people not feel comfortable actually bringing up problems that what their managers effectively telling them is put it under the rug, and that's how you help your team and help your organization. For other parts, say, bring it up to me, let's figure out how to solve this together, what we describe as psychological safety. I would say stronger organizations, not that they're perfect by any means, but they're actually actively seeking that kind of knowledge and information through, for example, qualitative surveys and other sources of information to understand where there are strengths and actually weaknesses, where there are those weaknesses and opportunities, actually devoting more compliance resources. This might be in terms of training, thinking about actually the types of manager, how the manager actually messages other people within the organization to try to encourage. But I think this gap is why people are so actually cynical about compliance. When we talk about compliance, it doesn't generally inspire a lot of, I'll say, excitement. People think it was this box checking exercise that oftentimes doesn't result in what they expect. And I think it's that gap. I'll just give one other example of that. If you ask a leader, a CEO of a company, what the company's policy for put like a misconduct, type of misconduct, whether we talk about bribery or harassment, and I would argue there's only one answer journalists ask you that we have a zero tolerance policy toward harassment. In fact, that's what every CEO has said over the last 4 years. If you actually go inside of a company, I would argue no company actually has a zero tolerance policy in the way that most employees think about it. Because employees think if the CEO says zero tolerance policy, then you say an off-color remark, or you do anything, you'll be terminated. And that's not how everyone appreciates. That's not how the world actually operates in companies. But that's what employees think, and that's what they expect. And so when they see the world, they see their CEO saying this, And then they see the world actually differs. For a lot of people, especially a younger part of the workforce, they become very disillusioned very quickly and very cynical, not just around, I would argue, kind of CEOs forced to say there, but around all those processes and systems. And so how do you maintain an environment where your CEO is still going to say we have zero tolerance policy when they are interviewed by the Wall Street Journal, or they're asked in an MBA classroom to a group of aspiring, people that might work for the company. But then simultaneously have your employees believe that the systems and processes do work when they actually do need to speak up. That's a challenge.
The very first words I strike from draft statements are zero tolerance, because I can't stand it for all the things.
And then
Go back to biting.
and then they come to a good point, and then someone asks, and then that is okay. You see, they're forced. I mean, they're forced to.
Yeah.
And I think that reflects the reality that there is no company out there that is perfect, that is going to have no misconduct. And that's why we all have jobs, frankly, because we are dealing with humans who have their motivations and are acting in different ways. One of the things that I wanted to go to was a discussion that was very lively this morning, was voluntary disclosures. I think that one of the things which all of us will recognize is that a whistleblower can impact a voluntary disclosure. And I'm just wondering from Mark, in your experience, right? How have whistleblowers, or how could they affect whether a company chooses to voluntarily disclose, when, or what a company will do prior to making a disclosure?
Yeah, so I mean, I described one scenario that was kind of a real case where like the audit committee and the general counsel get a letter from a putative whistleblower saying, here are all your FCPA violations. And by the way, I'm sending this, by FedEx to the Justice Department fraud section and the SEC. So in that case, like you've already made a decision basically in terms of no choice but to disclose, and whether that's even a voluntary disclosure at that point is probably a fair question. I mean, I think it counsels where there's a whistleblower in favor of sort of speed in conducting the investigation. It's counsel sort of can give the whistleblower kind of a bear hug and demonstrate to them, if you received it internally, that the company is all over it, that it's taking their concerns seriously, that they're being interviewed, that there's going to be follow-up to try to mitigate the risk that they then go to the government. But I think, there's always the chance that that's already happened, and you just don't know about it yet. So it's certainly, obviously depends on the facts, but it certainly is the potential inevitability of whistleblower going to the government obviously kind of creates an incentive to potentially get there first.
And Alan, from your perspective, right, how do whistleblowers impact in the UK or for UK corporates?
It's the same. Brian this morning used the word probability, so essentially it's about probability, and exactly right. What the board wants to know before making a decision about whether to go into the serious fraud office, what's the probability of the serious fraud office finding out about this without us going in. That means looking at what the facts are of that particular case, and one of those potential facts is whether there's someone there who is likely to blow this, who is going to go to the serious fraud office first. Just more generally, having made the point about key TAM and contracts contrary to public policy, our competition regulator, the CMA, Competition and Markets Authority, which enforces essentially a civil system, does operate a system of rewarding performance. And so there is a potential reward of up to £100,000, and that's issued in one policy document where it sets out the terms and conditions on which that can be done, and then the policy document which explains to the corporates about how they might get leniency, and the three stages of leniency, the three qualities of leniency which you might get. Type A, which is the most attractive, is one which is entirely essentially immunity, not less leniency, more immunity, is reserved for those people who tell the CMA information that they don't already have. and they put front and center of that policy document, by the way, here's a link, have a look at what we're doing for informants. So they use that as a way of trying to create an overt nexus between informants and corporate reporting.
And I think the driver that we have seen in among multiple governments is trying to increase the amount of flow of information, relevant information with documentation and other aspects to government authorities so that they can do these independent investigations or collaboration. But at times there are already government investigations or internal investigations. And once those become public, more whistleblowers sometimes come out of the woodwork. We've seen this a lot in the Me Too movement. And Lauren, I don't know if you would want to comment in terms of how can whistleblowers impact the path of a government or an internal.
Yeah, I mean, so in that scenario where it's gone public, you know, it's a whole different ballgame, really. There may be others that come forward, which can be helpful to the investigation. They see one person was brave enough to come forward, and so you have more information you can gather. It definitely is going to expedite the process because once it's in the public domain, however it gets there, the company is going to be under constant pressure to provide answers. And one of the biggest, you know, sort of issues that happens is somebody wants to provide the answers and they don't have them yet. And they get over their skis, you know, in public on the record statements about the facts, and they don't know them yet. So, you know, I think the biggest effect is that it's going to expedite that internal investigation tremendously from when it's just internal.
And Mark, what about your thoughts in terms of how whistleblowers can shape the investigation?
I mean, I think the other thing is that I agree with everything Lauren said with respect to speed and publicity. And obviously the first kind of objective is understanding kind of the underlying allegations that the whistleblower is making. But where there's a whistleblower, I mean, there are also very often kind of mixed motives in a whistleblower, and whistleblowers often provide information that's just false in many cases, whether that's motivated by trying to kind of buttress an employment claim because they're upset that they've been fired for legitimate reasons, and their information may be true, it may be false even in that scenario. But certainly we deal with tons of whistleblowers that make kind of false allegations or grossly kind of mischaracterize allegations in a way that are designed to, you know, enhance the value of an employment case. And in those scenarios, particularly where the whistleblower is dealing with the government, the investigation, you know, needs to be prepared to address kind of the credibility and motive of the putative whistleblower, because that will be relevant to kind of the discussions that we're having with the Justice Department.
Yeah, I think one of the other factors that I've seen, I've had various different cases which were absolutely in the press, right? And they're talking about it as subject to either U.S. Scrutiny or local papers. And those whistleblowers who go to local press can absolutely shape an FCPA investigation or a local corruption investigation where it had not been on the screen before, but all of a sudden you are, as a company, are suddenly not dealing just with the Justice Department, but you're dealing with lots of local investigations and law enforcement as well. And that can radically change how you approach it, especially if there's not necessarily an established rule of law in some of those countries. I can radically change the risks to your employees when you've got that. And whistleblowers, sometimes acting with mixed motives, can absolutely impact that. One of the things which was mentioned earlier is that whistleblowers, it's not fun necessarily to be a whistleblower, right? It is, I think in some discussions, right, it's like nobody is happy being a whistleblower, right? There are mixed motives for it, but usually at the end of it, they're unhappy with it. And I think part of that is the retaliation, the formal legal like employment retaliation or just personal retaliation. What are the things, and Eugene, as you said, that can allow them to overcome the feeling of being relaxed and reporting on their friends? Tell us a little bit about your thoughts on retaliation or what companies can do to minimize that negative action and minimize the risks associated with it.
Retaliations, I think, are really nasty creatures. They can take on a lot of different forms. There's of course what I call bad organizations who don't have processes. So basic one, you have policies to make sure there's not what I call formalized retaliation. I would say increasing, I think most reasonable companies now put them in place. And certainly some gray area will execute on that. I think what's more common, what people are actually fearful of, what I call are informal ways of retaliating. I'll just give an example of what this looks like in practice. Is that this is a project manager at a large company reported on her manager on something, very successful employee. And what did it turned out? Manager didn't agree, they didn't substantiate, but manager kind of came down with this person. What does manager start doing? Before key deadlines, remove calendar access on her calendar in like the 36 hours prior to key deadlines. If your job is to organize a team for key deadlines, like you screw up, you can't organize things because you don't know what's going on. Did this a couple of times. Ultimately, performance review starts going down. Also, you're just being screwed with it, and it drives you crazy. That's by all accounts an absolute retaliation because you're basically causing someone to have an uncomfortable work environment. So much so in this case, I know the person quit and how they ended up in business school. But plus one for us, a loss of the organization. I mean, it's absolutely a loss of the organization, but I'll say this is the kind of what I call retaliation that people most fear, because this is one that even if you're the best company with great investigative process, you bring all the outside counsel. Good luck trying to investigate all the pieces around this, because they actually can investigate this and it'll look like an IT error. But because actually the manager that I believe was doing this is actually this kind of what I call a really clever, really sinister type that knew exactly how to screw with the person just enough to get them to quit. In fact, actually, the person can't even really transfer because their performance is going down. So they can't even transfer with the company. Literally, they're going to be forced to quit. And that's just one, I mean, 30 of those kinds of examples of what people, I think, really fear. And actually, I think it's the challenge that companies genuinely face, because no policy or procedure is going to solve that kind of situation I just described. And so how do you actually, ultimately, I think when we start thinking about speaking up, try to resolve issues before they have to go to centralized processes that then cause them to be viewed as a whistleblower? Because the kind of issues I know called the situation I'm describing here, had this been addressed probably a couple months earlier in a much kind of lower key setting, it would have turned to a centralized call to a whistleblowing system, and wouldn't have created that kind of blowback that the manager felt that he was thrust upon him. And so to the extent that we have healthy culture to speaking up, high psychological safety, I think the best way for preventing retaliation is to be able to address it early, frequently, often, with pretty minor events. It's the single best way. That's hard, I think, for a lot of reasons we've discussed, but that's the single best way of preventing this kind of more abstract kind of retaliation.
We have a question from the audience. We could.
I can speak that. So you've mentioned that psychological safety a few times, which I think is really interesting. And I'm wondering, how do you measure that at a company, other than just by asking employees, do you feel safe? Is there a more sophisticated way to do that? How do you get to that stage? What have you seen employed at successful companies who have a high level of psychological safety when it comes to whistleblowing and related areas?
And so this is actually one of the kind of cultural metrics that one can actually measure with a high degree of consistency, because they're very well validated metrics. So generally there's between 4 to 6 questions that you ask a set of, you ask not just all employees, but just a subset of stratified or randomized subset of employees about how they handle disagreements, when they see problems, and better to kind of keep it close to the chest or actually bring it up. You ask a couple of these questions and you get a measure. One will actually see variation within the company. Most of the metrics around psychological safety, the set of questions, they've been validated not just for the company settings, but in fact, if you actually want to figure out if you have a surgical procedure coming up, where a lot of the original work on psychological safety, credit my colleague Amy Edmonds for a lot of this work. We actually think about the quality of the hospital or the surgical team. Turns out the most important metric is actually the psychological safety of the surgical team. If you actually where mistakes happen in a surgical procedure, it's when the nurse assisting maybe a well-renowned surgeon does not feel comfortable speaking up when they see something going on order. You want that psychological safety, that's how you prevent this. And so much like that's how you prevent it in the surgical context, you can take that as the same thing in a corporate context. But it's something that you have to ask people, because there's not really what I call it. It's a purely subjective measure, so it requires asking.
And I think we are running out of time, and what I love is for everybody just have some closing comments in terms of your own perspectives on whistleblowers, and any anecdotal examples that you think would be interesting, or top strategies companies could do, or on reporting or investigations. Just some closing comments, and we can start with Lauren.
Yeah, sure. I mean, I think it's sort of been a common theme today so far, but a lot of this speak up culture, having that security, it all comes from the top, right? So the executives that were in your executive class would say, like, I don't really even know what compliance does over here. Like, that's not helpful, right? So you need the top management to sort of be telling everyone, these things are important, this training is important, and we want to hear from you. And you shouldn't have any fears of retaliation, and to understand how all those mechanisms work, and really be like the face of it. Because the only way we're going to solve for this is that the employees feel secure and supported in bringing this forward.
Alan, your thoughts?
I think it's really important that and let's assume you've got good people in the company, the top of the company, who are getting the information. I think it's really important that understand it can be difficult for them too to hear bad things. That this comes something credible about something bad that's happened in the company. They themselves are on a journey when they try to make good decisions in the best interest of the company and the shareholders, and it can be really tough for them to make those decisions quickly. But I think, sort of thinking back to what was covered this morning, sometimes you do need to make quick decisions about how you're going to position the company. And so they've got a tough time too.
Eugene?
I think when we think about whistleblowing or compliance programs more broadly, there's such an emphasis and focus on the existence of and having these things in place. But if you actually look at the companies that are successful, where it's actually embedded as part of the culture, they're not looking at simply the inputs that they've completed X weeks of training, they have a hotline. They're actually looking at what the impact is. They're actually measuring. And so I think kind of business 101 is what you measure is what you manage. And so to the extent that an organization doesn't actually measure the impact of their compliance program, you generally don't manage it. You simply check a pile of boxes. And I think we're coming, I think, with the encouragement of more and more jurisdictions like the DOJ evaluation compliance programs, a rising sophistication among companies around the world in terms of what the expectations are in terms of measuring the actual impact of compliance programs. But I think we're still very early on that broader journey.
Mark?
And I guess I would just add to that, maybe that actions speak louder than words in all of these situations. And by the time kind of outside counsel is involved, there's probably a good chance something's gone pretty badly. And there's a lot that you can't really control historically at that point. But what you can control, at least those of us in these lawyer roles, is making sure that kind of the investigation is done in a really high integrity, kind of fact-based way, and cut square corners as appropriate to protect the interest of the company, but also make sure that if the whistleblower knows that it's being dealt with in an appropriate way, which is kind of all you can do at that point to kind of mitigate the risk of a unintended disclosure by someone to the government.
Yeah, I think the lessons that we have from all this is that information is going to flow in a lot of different directions, and how you interpret that data, right, will allow you to either detect something before it gets really big, or have it be a hidden bomb in your files, which will get turned over in some future discovery request. And trying to understand how you can most effectively devote your resources to identifying the right issues is exactly what I think Eugene said, right? Figuring out what's important in order to measure it, measure what matters. And that is going to be effectiveness on all of this. We live in an imperfect world. And we need to figure out how best to improve it with the limited resources that are there. And allocation of that to what is most effective is going to be important. Well, thank you very much. I know we have a little bit of time before the next session, which is on cybersecurity risks. Again, the flow of information, perhaps not the way that we would want it to. But thank you very much for your time. And we'll be returning at 2:45 for the next session. Thank you.